Alex here with part 58 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of this series. Two things that I'd like to glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, in a nutshell, the purpose of this series is to give my viewers one large example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off in parts 57 and 56 with the filing of 2 motions, and we are going into part 58 with the stipulation on those 2 filings. I recall mentioning that I suspected that these 2 motions would not go to a hearing, and I was right. My ex's attorney decided that she could get my ex to come to an agreement on the issues that I wanted to bring to the court's attention, which is a little bit ironic because last time I went to court, the judge was furious that I was filing all these motions, and the attorney could have tried to sort of go along with that and, go back to court and say, look, you filed 2 more. But she even knew, just like I have stated many times in the past, that the judge will not remember you. You can't use the sort of vibe or even the oral pronouncements from a previous hearing to get what you want in the current hearing. Lawyers know this because they've been doing this for years. And she probably knew that he had a duty to sit and preside and rule on the motions. He may have said before that he was going to get upset if I continued to file things, but it didn't mean that she could go into court and say that and he wouldn't say something like, what are you talking about? He's allowed to file a motion. Of course he is. These are reasonable issues. This is something that I tell people all the time. It happens. And if you haven't seen my video, the judge does not remember you. Take a look at that video. But it's also one of the reasons that I tell people, file something because it has merit. I talk about this in the video, attack, attack, attack. Don't try to read your judge and learn his personality and out-relationship the attorney. None of that stuff is going to work. What's going to work is following the law. And that's the general sort of rule that I would go along with. There are some attorneys who stand by the law doesn't matter, the rules, who cares? It's all about the judge. Learn the judge, make a relationship with the judge. Maybe that's true for them because they're lawyers and they went to school with these guys and they lunch with them and stuff. But we aren't lawyers. We don't know who these people are. We don't lunch with them every day. We didn't go to school with them. So we can't do all of that. The only thing we have is the law. So whatever was going through my ex's attorney's mind, she decided that what I was asking for was reasonable. And even though I filed 2 more motions after the judge yelled at me at the last hearing, she was going to get her client to stipulate. And she did. She contacted my ex, and it was, I remember it being a little rough, especially the portion of the child support, because she tried to wheel and deal with me on that. She tried to split the difference. She tried to say, okay, well, you're asking for $400 and your child support right now is currently, I think it was like $80 or something. So let's split the difference. And I remember replying, no, the formula is the formula. The law is the law. And my ex wants to follow the exact 5-minute rule for being late, and I want to follow the exact rule for the formula of child support. And I do remember her even mentioning to me that it was like a punch to the gut because it was like she was being punished for what she did. And I remember telling her, you know what? I'm not citing any of that in my motion because it's not relevant. I'm not mentioning anything in there about her being late. I'm just talking about the law. The law changed in 2009. I'm entitled to more child support. Now, I mentioned in my previous video, well, 2 videos back, that yes, the reason that I brought it to the court was because I was furious about what happened at the exchange, but that's not going to be a legal basis for what I'm asking for. So I didn't include that in the motion because that was not a basis for relief. The things that were included in the motion to modify child support were the things that were relevant to modifying child support. So all that being said, let's go ahead and take a look at what the judge has filed. Here we have the stipulation and order. Scrolling down, the first paragraph introduces to the court both myself and, well, no, it doesn't. It doesn't even name who we are. Okay. Usually that's what it does. But in this case, it didn't. Looks like the first paragraph, so the introductory paragraph doesn't do it, but the first paragraph might. Let's see, she's saying that if I am more than 5 minutes late, I agree and authorize my ex to drop our son off with my designee. And if, let's see here, petitioner will be responsible for whatever costs or fees are assessed by of course, yeah, of course I would pay those babysitting fees. I can choose an alternate babysitter so long as my current designee is not available. And it looks like to know, our son must know the sitter, and they must provide, well, that's a weird requirement. She used to come up with weird requirements like that all the time. Because, you know, when a child has their first day with their sitter, they don't know the sitter. I mean, I guess you could be friends with them or family members. So I suppose that works in the sense of non-hired sitters. Let's see here. Petitioner must provide my ex with the alternate sitter's name, address, phone number 30 days prior to using her. If I intend to use the alternate sitter, I can notify her by email 24 hours prior to using. Okay, I see. All right. So, by the way, recall how I mentioned in my previous video, I think it was 2 videos back, that once I set a procedure up that would frustrate her ability to do what she actually wanted to do, it wouldn't even be used. And that's exactly what happens here. We put together this procedure so that if one of us doesn't show up, she has to take him to a designee. And what happens in the future, because I'm not going to say we were perfect going forward, we would still be maybe 5, 10, 15 minutes late, especially her. She continued to be late. What would happen is we would just wait for each other. It's not like this was used at all. It was just a farce, really. It was just a pretext for her to deprive me of a visit. If this was a serious continuing problem, she would have ended up dropping our son off at the designee like 10, 15, 20 times. But it doesn't happen even one time. Because once she knows she's required by court order to take him to a designee so that I can go and get him, she just decides to wait for me. And that's what she does. And that's what I do for her. And for the most part, with one exception. And I remember that exception. She was late like an hour. I don't remember why. But with that one exception, we were able to facilitate exchanges throughout the remainder of the co-parenting relationship. Next, we have a stipulation that petitioner is allowed to. Okay, so she does give me the 2 additional makeup days. By the way, that was a contention. My ex's attorney said, she doesn't want to agree to that because it makes her feel like she did something wrong. And I'm like, well, if she's not agreeing to it, we're going to court. The next assertion is that on or before the 3rd week of May, when our child enters kindergarten, we agree to discuss and agree upon a modification of the midnight exchange time. An agreement to agree is unenforceable, by the way. There's nothing, you can't do anything with that. When a lawyer says, okay, we'll put this in there, we're going to agree someday in the future to something, it's just a wait. It's just fluff. It's totally unenforceable. You can't do anything about it. An agreement to agree is unenforceable. Next, we have the stipulation that I agree to send to my ex's attorney any information requested by the Department of Welfare. So long as she has an attorney, I will send informational requests to the council directly and not to her. Okay, whatever, that's fine. This was taken care of. As soon as her lawyer got the information that the Department of Welfare was requesting, the lawyer provided it to the department and everything was taken care of. Child support is hereby modified pursuant to Rivero v. Rivero 2009. And she went through the financials. It looks like she took my ex's gross monthly income. She took my gross monthly income. She offset the amounts and she came to a total of $405. And then, of course, my ex is maintaining medical benefits for our son. So half of that premium is deducted as a deviation downward, which dropped the child support that she owed me to $330 per month. Now, again, I haven't memorized what I was paying, or I wasn't paying anything. I haven't memorized what I was receiving prior, but I suspect it was around $80, $75, something like that. So my child support went up a lot. Well, the child support that I was entitled to receive went up a lot. Next paragraph is the child support calculation. Because it was greatly increased, I agreed to give my ex a grace period beginning on August 1st to assist her in adjusting her budget. So let's see here. Oh, so I was nice. I slowed it down for her. It looks like I gave her a delay until January 1st, at which point she would pay me $255.51 per month. And then it would increase to $330.51 per month. So it was kind of like a step up plan or something. I don't know what you want to call it. I didn't have to do that, but I went ahead and did it. Next, we have issues outlined in the petitioner's motion to set procedure for exchanges are fully and fairly resolved by the stipulation. And I withdraw those motions. So I withdraw the motion to modify child support and I withdraw the motion to set procedure. And this is how you do it. This is one of the ways that you can get a high conflict X to come to an agreement. It's not by sitting down and having a reasonable discussion. It's by filing motions. Motions put their back to the wall. They trigger deadlines. They trigger hearings. And confronted with the potential embarrassment in court, they will sometimes, not always, sometimes they will decide, okay, I'm going to agree. And again, I talk about this in the video delay tactics. It's an absolutely crucial video. I also talk a little bit about this in the video sabotaging settlement. So definitely take a look at that video as well. This is the boilerplate portion of the order. I talked about this before. In Nevada, we have a statute that requires judges to include this paragraph about child abduction in any order that they enter in a child custody action. And it's just something that they just have in all of their court orders, just so that if somebody decides to take a kid and run, if they're apprehended and brought to justice and they try and claim, oh, well, I didn't know I could run off with the kids, you can show like 7, 8, 9, 10, 20 court orders where they were told over and over again that they're not allowed to run off with the kids. And then he signs it. And that's it. Next document is the notice of entry of order. This is the document that triggers the date to appeal an order. And I talk about this a whole lot in a video that I dedicated on the topic. I'm not going to talk about it again right now, but that video is titled Notice of Entry of Order. And again, it has to do more so with the time limit to file an appeal and less so with actually notifying you of the court's order. And the reason I say that is because, as far as I know, anytime a court enters an order, they mail it to you themselves. So this is just an extra notice that you get from your ex's attorney, with the exception of the fact that it triggers the deadline to file an appeal. That is actually something to pay attention to. Certificate of service by mailing, indicating that she mailed it to me under Rule 5, which is allowed. And the index of exhibits, which is going into Exhibit 1, stipulation and order that was entered. I'm not going to go any further into this document because we have just gone over that stipulation and order quite literally 2 minutes ago. Next, we have these minutes. This is odd. What's odd about these minutes is that this is in regards to the hearing that was held on February 23rd, 2010, but they were filed on July 29th, 2010. So 5 months later, the court files the minutes on the hearing that was held in February. I can't say that it's something that happens all the time, but I can't say that it's something that rarely occurs. It's one of those things that it's uncommon, but it does happen in these child custody cases. I don't know how things slip through the cracks, but they do. So this copy of the court's minutes is very, very, very late, and it goes over a hearing that we have long since discussed. I'm going to glaze through it very quickly to see if anything jumps out at me. We already have a final order on these minutes anyway. Nothing is jumping out at me that we haven't gone over in the final order. It's just going through what we discussed at that hearing. I think it was in part 20. No, wait. Oh, I can't even remember what part of the My Docket series it was. I think it was 29, but that doesn't sound right. It doesn't sound right at all. Again, nothing jumps out at me. This is all stuff from back in February. This is where the court ordered my ex to give me 14 days notice. But again, the minutes aren't enforceable anyway. The court order, the final written order, which we went over quite some time ago in the My Docket series, is the enforceable portion of the actual 14 days notice provision. So that's basically the end of these minutes. Going into the aftermath, the judge and we entered a stipulation. That's a free filing. The notice of entry and the minutes, I didn't enter either of those. My ex's attorney entered the notice of entry, but that's a free filing as well. So I incurred $0 in costs, and my ex's attorney incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have prepared that stipulation. That would have taken time, and that would have also taken consulting with my ex. And I do remember that being quite a bit of a back and forth. I think that my ex was really pushing her bargaining tactics, bargaining skills, and it kind of went down to the wire based on the fact that I had to file a request for submission because I felt like they weren't even filing the agreement. So the fact that it went down to the wire, the fact that I recall going back and forth on issues, even silly ones like the makeup time, the fact that I recall her trying to wheel and deal with the child support amount itself, I'm going to say that the stipulation itself probably took the attorney, let's say 30 minutes to prepare and an hour in negotiations. So we're looking at an hour and a half there. The notice of entry of order, it's negligible. It's like a 1 or 2 page form filing. And the minutes, I mean, those minutes were so old, I doubt she even cared to look at them. So let's just leave it at negligible for those 2 filings. An hour and a half for that stipulation and order and all of the discussion that would have occurred with the attorney and her client and also the attorney and me. So an hour and a half at a rate of $250 an hour, that's going to come to $375 in attorney fees. And as with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.